Friends, I am BC Thomas, a visiting faculty of IIBF. In this session, we would be discussing on Insolvency and Bankruptcy Code 2016. Friends, why this government has enacted this Insolvency and Bankruptcy Code? We would be discussing on the background. See, first of all, this insolvency and the enactment of this Insolvency and Bankruptcy Code, we call it as IBC, was enactment of this one was to take care of. It can be treated as a watershed in improvement of the credit culture in our country. Prior to this enactment of this IBC, there were laws, multiple laws, multiple overlapping laws, which governs the facets of corporate rescue and or insolvency process. In the insolvency process, without a comprehensive legal framework that envisage a holistic process, that envisage an holistic process applicable to the troubled or defaulting companies. The legal and institutional machinery for dealing the debt default, namely, they report that either it may be under Indian Contract Act 1872 or other special act, that is Recovery of Debt due to Banks Act Banks and Financial Institutions Act 1993, or that we can say the SURFACE Act, Securitization and Restructuring of the Financial Asset and Enforcement of the Security Interest Act 2002, that is known as the SURFACE Act. These acts were not used well by the banks. To recognizing that the reforms in the insolvency and bankruptcy regime is inevitable for improving the business environment and alleviating the distressed credit market. The government of India has enacted the Insolvency and Bankruptcy Code in 2016, precisely in December in 2016. And this act, IBC Act, came into force with effect from December 2016. Now, this act provides the most important thing, it's a single window approach, in the sense that the particular act, it will take care of the viable unit, it will take care of unviable unit also. Both the cases, the resolution plan would be there for taking care of the viable unit, and other one is for liquidation process. So under one act, both the things are taken. So we can say that the single window concept or single window approach. Another area is another provision under this act is that, under this code is that time-bound process for resolution of the asset. Time-bound process in the sense, as per the act, as per the code, or as per the act, IBC Act, the resolution plan should be completed within 180 days. And in exceptional cases, if the creditors committee agrees with the absolute majority, that it can be extended, further extension to the extent of 90 days can be considered, making total number of days for 270. That is very, very exceptional case only. Else, the resolution plan should be completed within 180 days. That is why the time-bound process for resolution of the asset. And the third one is an explicit emphasis on promotion of the entrepreneurship. Here, under this code, if the existing people are not in a position to deliver, then a change in management, provided the unit should be viable. Change in management, thereby bringing new promoters, and the entrepreneurship can be inculcated or can be brought into with this act. Another feature of this, or another provision of this act, is that the maximization of the value of the asset. Perhaps you must be reading in the media that many units are under insolvency, under liquidation, and the value, its open bid is being raised, and the value would be the people are participating in the bid, thereby the value of the asset are getting increased. So that is why the maximization of the value of the asset. Then this, by doing this, and it is balancing the stakeholder interest of all the stakeholders. It will balancing the interest of the stakeholders in the sense by giving more money, especially the creditors and the other pressing this workers dues and other thing. All the people are getting due share in the process. So these are the provisions, broadly the provisions available in the IBC 2016. Now this IBC Act is applicable to, that is insolvency, then liquidation, then there is a provision for voluntary liquidation also, we would be discussing later part, and finally bankruptcy. These are the 4 provisions under this act. Now coming to who are the means coverage, just like which are the parties can be covered under this IBC. The first one is, we can say that any company incorporated under the Indian Companies Act 2013 or earlier acts, or any corporate or any entity in company governed by any special act. Special act means by act passed in the parliament by the government, and special act the corporate is formed. Then any LLP means limited liability partnership formed under the Limited Liability Partnership Act 2008. LLP is also one of the parties which can be participated in the IBC process. Then any other body incorporated under any law for the time being in force, as the central government may notify. Based on the notification of the government, any other units, any other corporates, any other entities can also be bought within the ambit of the IBC. Then individuals and partnership firms. Individuals and partnership firms. But there are certain exceptions. Who are not the financial service providers are not eligible, are not covered under the IBC. Financial service providers including banks, insurance companies, mutual funds, and other financial institutions, etc. These people are exempted from this IBC. So these are the this is the coverage of IBC. Any company incorporated under the Companies Act or earlier act, or under special act, any corporate under special act, or any other this one as notified by the government of India, or LLPs and set up under the LLP Act 2008, partnership and individuals, or financial services providers, they are not covered under this package, under the act or under the code. Then we can discuss about what are the purposes, or what is the purpose or objective of this code. This code, perhaps you may be knowing that prior to implementation or enactment of this act, as I told you, there are multiple or overlapping laws which govern the facet of the corporate corporate rescue or insolvency. But here, the consolidation of the all earlier act or earlier act and amendment to the laws, earlier act or amendment laws, consolidating, and one act was passed. As I told you, there is first one single window concept, single window approach. That is for viable unit as well as non-viable board. Both are taken care in the IBC code. So the insolvency second one, we can say that there is one is consolidation and amendment of the laws. And again, we can say that insolvency resolution process, insolvency resolution of corporate persons, partnership firms, and individuals. This another object is insolvency process, insolvency resolution process for corporate, partnership persons, partnership, and individuals. Then another objective is to fixation of the time. And unlike in the other laws, it may be indefinite. No, here the time frame is fixed. As I told you, it may be 180 days, or at the most, in very very exceptional cases, it can go up to 270 days. Then, as I told you, the maximization of the value of the assets of the interested persons. Assets is under the act, under the code. An open auction would be there. There we will get the maximization, we will get the maximum value of the assets, which would be the beneficial of the stakeholders. Then promote entrepreneurship. As I already told you, this provision is there to remove out the existing one and replacing the earlier this existing promoters by new entrepreneurs, thereby explicit emphasis on promotion of the entrepreneurship. Then increasing availability of the credit. Once the unit is found as a viable one, then lenders will also consider, in case of need, further enhancement in the credit, enhancement in the need-based credit wherever it is required. Then balance the interest of all stakeholders, as I told you, including alteration on the order of priority. The order of priority, of course, in the later part we are touching. Which one is the order of priority? As a banker is concerned, they are a secured creditor. But prior to that, secured creditor, these dues of the workman also would be coming. That we will be discussing in the later part. What is the order of the priority? Along with the workmen's, this secured creditor also will be considered under this act. Then establishment of an insolvency and bankruptcy board of India, that is called as IBBI. Establishment of an insolvency and bankruptcy board of India as a regulatory body for insolvency and bankruptcy law. So there is a regulatory body would be there. Excuse me. That is known as the Insolvency and Bankruptcy Board of India, IBBI, for insolvency and bankruptcy law. So we have seen what is actually the background. We have also seen what are the coverages, coverage of this one, and comes to the purpose and objective. Now comes, then we can say the pillars of IBC. There are, just like in a building, there are 4 pillars. Like here, there are 4 pillars. One is insolvency professional. The second one is concerned with the information utilities. And the third one, we can say that adjudicating authorities. The fourth one is Insolvency and Bankruptcy Board of India, IBBI. These 4 agencies, 4 entities can be considered as the pillars of the IBC. And then what is insolvency professional? Insolvency professionals, their main role is to assist in completion of the insolvency resolution, liquidation, and bankruptcy proceedings. They're to assisting these people, assisting the completion of the insolvency proceedings, resolution, that is for viable units, then liquidation if it is not viable, and finally bankruptcy proceedings. They're assisting this one. And their insolvency professionals are regulated entities, and they are coming under the Insolvency Professional Agencies Act. That is within the IBC Act. This will come. So they are regulated, and the regulated persons who will develop, and these people, means insolvency professional, that is IP, we can call it as, develop professional standards and ethics and code of professional standards and ethics, and the code of ethics as first level regulator. First level regulator, these things would be there is a standard, professional standard, and code of ethics. These are all these things are to be these are being developed by IPs, that is insolvency professionals. Then to become an insolvency professional, as I told you, the regulated, they are coming under the insolvency professional agencies, and they will have to clear one exam that is known as limited insolvency examination. Unless that person who is inclined to work or interested to work as an IP insolvency professional, it is mandatory that the person has to clear the limited insolvency certification or limited insolvency examination. Once it is cleared, then only the person can be said to be eligible for being considered as an IP. And it is mandated, and these provisions are mandated under the Insolvency and Bankruptcy Board of India, that is Insolvency and Bankruptcy Board of India, Insolvency Professional Regulations 2016 under the IBC. These we can say that subsections of the IBC, this will come under this one. These insolvency professional will come. And the second pillar is information utilities. Information utilities are another agency or another pillar where their main role is for the collection of the data, then collection, then authentication and dissemination and maintenance of the database on lenders and terms of lending. That is data, everything ready-made, means data storage would be there, entire data regarding this unit and all. Second one is the data would be collected, then authentication of the data, then dissemination, it is passed on to other people involved in this process, and maintenance of the database so far as the lenders, details of the lenders, the terms of the lending, all the things would be there, so that the matter can be, the decision can be expedited. Instead of referring to the respective lenders for all this data, all the data are readily available. Database would be built up by the information utilities, and they would be utilized for this kind of expediting the resolution process of the unit, which are referred to IBC or IBBI. Then the third pillar is adjudicating authority. That is very important. Adjudicating authority. Under this, we have seen that coverage, that is corporates. We have also seen that LLPs are also there. Then partnership firms, individuals are there. They are all covered by the code or IBC Act 2016. So here there are two adjudicating authorities. One, that is the first one is, so far as there is NCLT, National Company Law Tribunal. We call it as NCLT. And this tribunal, they got an appellate authority also. That's the National Company Law Appellate Tribunal. These two, NCLT and NCL, we can call it as NCLAT, National Company Law Appellate Tribunal. And all who are eligible in the case of corporate and LLPs. In the case of corporate and LLPs, they have to refer to in the case of the debtor or company, the corporate and LLPs, the limited liability. They have to the matter should be referred for resolution or liquidation to the NCLT. And if the NCLT passes an order and the aggrieved party is not satisfied, they can, as per the Act, make an appeal before the appellate tribunal. And appellate tribunal, as I told you, NCLAT, National Company Law Appellate Tribunal. And that too within 30 days of the date of the order passed by NCLT. Within 30 days. And 30 days in exceptional cases, some 15 days time can be given. That the committee, that is the creditors committee will decide. So 30 days time, the total maximum 45 days. But normally, within 30 days, the appeal should be placed before the NCLAT for any grievances. And again, suppose the aggrieved party is not satisfied with the order passed by the NCLAT also, in that case they have got an option to make an appeal before Supreme Court only in respect of that matter relating to law. No other this one. Any legal point, any dissatisfaction is there, it is not taken care of. In that case, they have got a resort, last resort, that is the Supreme Court. But please bear in mind that this can only be available in case of anything relating to the law. So far as corporate and LLPs, that is NCLP, NCLT, National Company Law Tribunal, and Appellate Tribunal, NCLAT, National Company Law Appellate Tribunal, then it should be within 30 days, appeal should be made, and exceptional cases, 15 days time may be granted. So that is maximum 45 days, or in the normal course it is 30 days. And the aggrieved party can, if the order passed by the NCLAT is not acceptable or not acceptable, they can make an appeal before Supreme Court only in case it is a matter of law. In that case, will it go. And who are the left out now? Individuals and partnerships. Individuals and partnerships, their cases have to be referred to DRT, Debt Recovery Tribunal. And Debt Recovery Tribunal, they have got Appellate Tribunal also. That is DRAT, Debt Recovery Appellate Tribunal, DRAT. Here also, an order passed by Appellate Tribunal, order passed by the DRT, Debt Recovery, that is a Debt Recovery Tribunal is meant for individuals and partnership. And any aggrieved party, they can make an appeal before DRAT within 30 days. There also, in very, very exceptional cases, 15 days time would be given, further time, so making 45 days, that two very exceptional cases. Normally, it is 30 days. And suppose the party is not satisfied with the order being passed by the DRAT, in that case, there is a provision they can go to Supreme Court. There also, it's only in the only on in the case of law. That is only in the case of law they can go. No other issues can be taken up before the Supreme Court. Supreme Court will not entertain. Law based relating to the law, any dispute is there, that can be taken care of by the Supreme Court. That is the last resort. Then the fourth one, we will take it in the next session. The fourth pillar, we will discuss it later on. In the next part, this is part one. We have already discussed IP, insolvency professional, then information utilities, then adjudicating authorities in detail.